Well, thank you, Francella, for that amazing introduction, and to Ben for setting us up. Thank you to Next Century Cities for putting on what has been, I think, an amazing conference, and to our friends here at Google for hosting. I'm John Breyault with the National Consumers League, and because we don't just want the panel to be bipartisan, we also want the moderators to be bipartisan. So I'm really proud to share the moderating responsibilities with you, David.
Well, thanks, John. I'm David Redl. I'm the president of Salt Point Strategies, a consulting firm here in town. I'm happy to be here as well. I apologize to the panelists to whom I am talking to your back. That the wealth of riches that we have on this panel means that the chairs are in an awkward shape. In the spirit of giving everyone the opportunity, particularly on a privacy panel, among other things, to introduce themselves. If everyone could go through, we'll start down at this end and we'll make our way down to give us their name, who they're working for, a brief overview of what they're working on, the last 4 digits of your social security number, and your mother's maiden name.
Hi, everyone. I'm Laura Moy. I'm an associate professor at Georgetown Law School. I also direct the Communications and Technology Law Clinic there at the law school, and we do a lot of work on consumer privacy issues, including children's privacy issues, broadband privacy, privacy legislation to some extent, lots of related issues.
Thank you for having me. My name is Jeremy Greenberg, and I'm a policy fellow at Future of Privacy Forum, or FPF for short. We are a DC-based nonprofit that brings together industry, academics, advocates, and other thought leaders to promote responsible data use in emerging technology. And we are very involved in the discussion of federal privacy legislation, as well as legislation in the states and at the local level, especially in the smart cities space.
Great. My name is KJ Bagchi, and I'm Senior Counsel at Asian Americans Advancing Justice, AAJC. Our focus in the privacy debate has been bringing in the civil rights perspective, as well as focusing on communities of color, and trying to represent the diversity within the Asian American community itself, which is not monolithic.
My name is Sean Perryman. I am with the Internet Association. I am the Director of Social Impact Policy and Counsel at the Internet Association. We are a trade association here in DC that represents several of the leading tech companies in the public policy space. And I'm excited to be here. I work on all issues from AI to D&I to sharing economy related issues. So thank you.
My name is Jennifer Huddleston, and I'm a research fellow at the Mercatus Center. We're an academic research center based on George Mason University's Arlington campus with a goal of bridging the gap between academic ideas and real-world policy. Broadly speaking, my research focuses on the intersection of law and technology, which today means a lot of focus on data privacy issues, online speech and content moderation, as well as transportation innovation and administrative law.
My name is Tom Lenard. I'm a senior fellow and president emeritus at the Technology Policy Institute. I'm an economist. Most of the work we do at TPI is economics related. I'm focusing these days primarily on privacy and competition issues in terms of platforms and the interrelationship between the two.
So thank you, everybody, for the introduction. I think, as you can tell from their brief bios, we really do have 6 of the smartest people in the city when it comes to privacy issues. So what we're going to talk about over the next 50 minutes or so is talked about through a lot of buzzwords that you're probably familiar with, things like algorithmic bias, disinformation campaigns, data leakage, smart cities, Internet of Things devices, and I think they all come under the header of, how do we deal with these? Well, there's going to be some form of platform regulation, and so what does that mean? Who's going to do it? How should Congress handle this? And how can we make sure that the debate that happens around all of these issues includes everybody who's affected by the debate? I think too often we see really critical voices excluded from the conversation or not fully included in the conversation. And so we're gonna try and go through as many of these topics as we can with our panel. So I'm gonna just start it off, a toss-up for the panel. Is federal legislation the best way to ensure clear and consistent consumer privacy?
I'll start it off with the Internet Association, so I'm going to say yes. I think right now it's something like 25 different states in Puerto Rico have some version of privacy legislation at the state level or the local level. Right now, I don't think that this patchwork framework really recognizes the economy that we're currently in. On any given day, you are doing business across state lines if you're working on the internet. And there's no reason why, let's take two states, for example, Nevada and California. They have very different privacy laws. There's no reason why, if you're doing a transaction, you should have one protections here and another protections there. So I think federal privacy legislation ultimately will be the best at protecting all consumers across the United States.
I would also say yes. We have seen other areas where states and cities are really able to be leaders in technology policy. But when it comes to privacy and data, this really is an issue that, because of the nature of the internet, because of the nature of data, has to be addressed on a national level.
So I'll agree that having federal privacy legislation is the best way to have clear and consistent rules. But I also think that it's important to note that clarity and consistency are only two goals, right? And there are many goals that one might want to achieve with privacy legislation. One is strength. And strong consumer privacy protections won't necessarily come from federal privacy legislation if we can't get there.
And I would just say to that, anything that we have that's federal privacy legislation, and we talk about federal preemption, it has to be worthy of preemption. It has to be something that is protecting consumers. So I don't think that saying federal legislation is necessarily saying weak legislation. And I think sometimes that gets conflated. But right now, there are states with no protection at all. So there has to be something done, and I think that's where we need to start pushing people.
I was just going to agree with some of the things. Federalism is good for some things, but I don't think this is one of them, because of obviously the interstate nature of the commerce, that information flows all over, not just nationally, but internationally. And we probably also don't really want a situation where one state, by default, even if it's a big state, determines the rules for the whole country.
Well, Tom, you teed that up awfully well for me, so I'll just take it from there. That is effectively what we have today, is it not? With California having set the baseline, I can say for myself, I've thoroughly enjoyed the new round of click whether you're in California or not on websites. Since that is effectively the de facto standard right now, is that where Congress should start looking?
Well, if it's a de facto standard, then if you want that standard, then maybe you don't have to do anything, just let California do it and the rest of the country will adapt. I think there obviously are advantages to the federal government trying to come up with something better than what California has come up with, and obviously including preemption.
I just want to point out that California is the state that has passed a consumer privacy law that applies to a wide swath of consumer data, but there are lots of other states that are also establishing standards here, right? So we would be remiss not to mention that Vermont has passed a data broker law, that Illinois has passed the Biometric Information Privacy Act, that Maine has passed a broadband privacy law, right? So when we say, oh, there's a de facto standard, it's the California standard, I think that we're missing out on the fact that there is privacy legislation being passed in all of these other areas, and there's an open question as to whether, if we have federal privacy legislation, it will cover those other areas as well, or will it just essentially replicate what California does, which, by the way, I also think is not quite strong enough as a starting point to actually address the question. But
Thank
yes,
you.
just wanted to point out that there are other areas not addressed by the California law.
And now there's another ballot initiative
Yes,
in California.
exactly.
Yeah, and I have to agree with Laura in that, CCPA, it's being talked about as the new sort of standard that everyone's looking toward, but we have all of these sector-specific laws and proposals at the state level, and we also have some broad privacy bills coming out of Washington, for instance, which is probably a bit more akin to GDPR than CCPA in many respects. So I think that at the federal level, folks should be looking at really the wide spectrum of what we're seeing across the states.
Well, I also think that wide spectrum, though, raises the question of, in some cases, it may be that one can simply apply California's law writ large, but in other cases, you can have laws that conflict. And what happens when you can't comply with two states' laws at the same time is going to be a question both for consumers and what that means for the future of innovation and entrepreneurs.
So, we talk a lot about, we've been talking about sort of past few minutes, privacy laws, right? But I think when you talk to consumers about what concerns you about privacy, they tend to focus on, at least from my experience, particular uses. And so let's take facial recognition, for example. This is one where you're starting to see a tremendous amount of grassroots action. When I have sort of my 80-year-old father-in-law asking me about, what's up with facial recognition? Like, I kind of figure that's starting to bubble up to sort of mass interest in this issue. And you see cities actually taking action on their own to restrict the use of facial recognition. Or let's take algorithmic bias, for example. All of these little subsets that sort of come down under the larger heading of privacy, where there does seem to be action being taken at certainly the state level, but also at the local level. So how do you take, is sort of the I'm going to say balkanization of privacy action to deal with specific use cases, for example, like face rec, good or bad for consumers and for the efforts to get, let's say, a federal privacy bill over the finish line?
So I'm going to say that without speaking necessarily to the substantive standards that arise from what you might refer to as balkanization, I do think that there's something to be said for legislative agility, right, or regulatory agility, as it were. That what we see happening with the states right now and with localities is we see areas quickly responding or attempting to respond as quickly as they can to new issues that are popping up that they view as particularly problematic, and they happen to be able to respond faster than our federal legislation has thus far been able to do. And so, I think, so I would agree with the point that, that we shouldn't even talk about preemption until we know that there will be a strong federal standard. But I also think that it's important to note that a strong federal standard that is static is not enough, because not only do we need to have a strong federal standard, we need to have a federal legislation, if we're going to have federal legislation, that creates or replicates a mechanism for that regulatory agility that we're seeing at the state level. So if we're not going to have states and localities innovating on privacy, responding quickly to arising concerns, what mechanism will we have? And and there's lots of ideas out here on this as well. Is it going to be robust rulemaking authority? Is it going to be a new data protection commission? That's something that folks have talked about. Is it going to be floor preemption that just sets a baseline standard for privacy protections and then allows states and localities to continue to institute rules that are stronger than the federal standard?
So I would just say a couple of things, not necessarily in response to that, but related to your question. Most of the leading federal privacy legislation does not address government use, and that's concerning. When we talk about cities and states using them, yes, there are some that are leading, but there are a lot of cities that are adopting facial recognition without these regulations, without these standards, and it's especially concerning to me in areas that don't have broadband connectivity, where you think about if you are the average citizen and in your home you don't have reliable internet connection, but you're going out and you could be possibly being surveilled, The only time you're encountering AI is in this surveillance state. You're not getting any of the benefits of it, you're just getting the surveillance. And I think we really need to think about that when we talk about privacy. We sometimes focus on these companies and do not talk about government use of it, which is particularly concerning. So I just wanted to interject that.
Well, and if I could just build off of that, I think that even, you asked about these more specific cases, but even terms like facial recognition, algorithms, AI are themselves very broad categories. And so there are certainly very beneficial uses, and I think there are a lot of potentially advantageous uses to individual consumers, as well as in some cases potentially to different government entities. But there are some civil liberties concerns that will need to be addressed. And so even looking at the specific uses, the applied uses, and trying to address those concerns.
Well, I don't think we want a balkanized system. I don't think balkanization is good, but I do think we want a system that allows for different privacy preferences. I mean, everybody doesn't have the same privacy preferences, and obviously, to the extent you have a very, very stringent standard, you're really not allowing for different privacy preferences. And when we talk about what consumers say, we actually also need to kind of take into account what consumers do. The well-known privacy paradox, that notwithstanding that they say they're very, very concerned about privacy in various surveys, et cetera, they quite willingly trade their data for various various services. So, as an economist, we're trained to basically watch to put more credence in what people do than what they say.
If I could jump in real quickly. So I think in DC, we have a tendency to, especially in the privacy debate, we talk about consumers as a sort of monolithic block. And in the privacy debate, you're hearing a lot about what companies should be doing and how smaller companies may not have the resources to comply, and that's where the debate has been. But we can focus it a little bit on the diversity within the consumer base itself. You have individuals who are going to have varying levels of education, varying levels of English proficiency, and even within the federal legislation we're looking at, just the idea of how terms of service should be presented to the consumer are varied. So from a federal and national civil rights organization perspective, when we're thinking about clarity and consistency, I agree it is just two values, but in terms of when you're looking at the consumer who's trying to understand between the states they're living in and clicking on if they're in California or not, that comprehension, it is important to have more consistency there. And so I do think it's also interesting that we sort of keep tiptoeing into the preemption debate, but it is hard to support the idea of a strong federal law if you don't know what's on the table, right? So I do think that's that's why I think we're having this sort of amorphous debate between should states be able to build on this, and they should. They should be able to build when there's sort of lack of federal action. But from our perspective, from our organization's perspective, we want strong federal law, and that's why we're working with policymakers and industry, frankly, to push that through.
So again, KJ and Jennifer, I think both hit on two sides of an issue here, which is that when we have the conversations about topics like privacy or any other technology policy, we tend to overgeneralize when we have these conversations, and that happens at every level of government. As you all look at state, federal, local, all the different levels of government, do you think that those levels of government have the requisite expertise to actually find their way through this forest and get to solutions that make sense for such a nuanced policy area? Stumps them. It is so much nicer to be on this side of this question for once.
I'm gonna answer this question by talking about the sort of lack of resources for technical expertise at all levels of government, right? And to say that, so I think everybody is lacking in resources for technical expertise. including at the state and local level, but also at the federal level, right? And I'm thinking in particular of agencies here, and about the fact that our Division of Privacy and Identity Protection at the Federal Trade Commission has only, Ben would be a better person to speak to the current number on this, but I think it's between 40 and 50 staff, right? And that's for all privacy and ID theft, data protection across the entire country, everything that the FTC is supposed to cover. And meanwhile, you look at other countries that are prioritizing privacy. If you look at the UK has 500 people in what's it called, in the Information Commission. So if you took that number, if you applied that, if we had an agency of a similar size here in the U.S., it would have 2,500 people, right? Instead, we're looking at 40 or 50, and with very little ability to hire specific dedicated technologists, and I think it's really a problem at all levels. And I think one of the things that legislation absolutely should be looking at is how to give more resources to governments to be able sufficiently to understand not only the legal challenges but also the technical challenges.
Well, I think obviously, I don't think Congress has the capability to get into all the details. So I think they should specify broad principles, and then they should hand it over to an expert agency like the FTC. I think actually the United States approach to privacy as administered by the FTC has lots of good things to say about it, lots of strengths in comparison to other regimes. And the basic good thing about it is that it's kind of an ex post regime that is based on, it's a harms-based approach. So if there's something that has caused harm, then the FTC has the ability to go after it, rather than a kind of an ex ante approach which prohibits various types of data activities regardless of whether they're going to cause harm or not. So I think the Congress, and I don't know that they're actually doing this, but I think they would be well advised to try to build on the current approach and strengthen it.
I just want to push back on that a little bit, because a majority of Americans have said that they believe that the current privacy problem is a crisis, right? I mean, and notwithstanding the point that you just made a moment ago, Tom, that people are still using online services even though they express discomfort with the privacy challenges, I think consumers are. I think that they are resigned to the fact that they can't do anything about this problem, but they are responding in great numbers in polls and telling government that they want greater privacy protection, right? 75% of people responded to a recent survey and said that they believe that government should be doing more to protect privacy. So the ex post may have been fine at one point in time, but I think it's very clear that the system that we have right now is not sufficient. I think a lot of people would prefer prospective rules that tell them what the rules of the road were, as it were, in advance, and people really do think that this is a crisis.
So just to jump in on this, I mean, so we've established that the agency that we are looking to be the primary cop on the beat when it comes to dealing with all of the privacy issues that we've talked about is underfunded, underpersoned, and in many ways lacks the expertise necessary to carry out the mission that Congress is considering giving to it. So until that is fixed, who should Congress, and by extension, the people who have elected them, look to police commitments that are made here? And is it the AGs who are going to do that? We know the AGs look for big splashy cases because they're in a lot of the same problems that the FTC does: undermanned, underfunded, not enough expertise. So from my perspective, I say, well, maybe we should look to somebody else who has an incentive to police this network, and that gets to private right. There is, it's trench warfare on private right. You either believe it or you don't. Is that right? Are the sides forever irreconcilable when it comes to a private right, when it comes to privacy and data security? Or is there common ground to be found involving the plaintiff's bar or in this issue?
So I guess I'll take the first stab, and I imagine everybody else will go after it after me. So for me, I approach it from a sort of unique perspective. I was working on the oversight committee when the Equifax breach happened. So I was counsel there. So both the patchwork framework, where I saw, the 50 different notification letters that had to go out, and I'm still bitter about that discovery process for that. But I saw that, and it was just the most ineffective thing. But then when we look at the end solution of what happened, Equifax, that was a class action suit. That was private right of action. And you had a $300 million restitution fund that was set up. $77 million went to attorney's fees. Okay? And most people are still trying to get their free credit protection rather than money. So I sort of...
What was the average amount that went to the...
$125. So...
And didn't they run out of it as well?
Yeah, it ran out. So when people talk about private right of action as if this is the access to justice, to me, as someone who does social advocacy, I don't see it. But I think what you're saying with the FTC, I think we could all agree that that problem needs to be fixed before we talk about a new privacy regime. If we were to fund the FTC better, if we were to give them the resources that they deserve, then maybe we could all be on the same page. But that's my perspective on it. But when I look at private right of action, that to me does not make a person whole. And the incentives are wrong.
So I just want to point out that making a person whole is a good goal of litigation, and it is a shame that people didn't get more out of that settlement. That said, though, there's one of the goals of litigation and of enforcement generally is to make an example of a violator so that others hopefully don't violate the same provisions in the future or similar provisions. It's to make violations painful so that others will see the pain and hopefully act differently. And private right of action has the potential to help with that. And you asked about state AGs and just to point out that the California State AG's office has said that they may only have the resources to bring maybe 3 prosecutions a year of CCPA. And again, they're very limited in resources. So is the FTC. Someone needs the resources to do it here. Private right of action helps get us there. And then just one final point about private right of action is that private rights of action have historically been included in civil rights laws. And one of the reasons for that is because small numbers of people who are harmed by something, or minorities or people who feel underrepresented, may not have their rights vindicated in court by an enforcing agency and may need to rely on themselves.
I just have to push back on the idea that private right of action puts pressure on the violator and you'll know what they did, because you can have a private settlement where you have no idea what happened and you don't know that's why at the FTC at least you would have you know what they did, there's a fine imposed and everyone knows it, and that would set the example. If you have a private right of action with a confidential settlement, you don't even achieve that. So you're not only not making the person whole, you also aren't really exposing what happened.
You can also have strong incentives to reach that settlement rather than to pursue it all the way through a court case, even if in the end you would be shown not to have violated it. And you also have that question of what does that do if you have something that maybe is in a gray area or that could be beneficial? Are you going to take the risk if there's a possibility that litigation could be industry ending or business ending?
So we haven't taken a formal position on private right of action, but a question I would pose is who does it benefit? Because if it's a consumer, we're looking at a case study that was brought up here. It's not there's no restorative justice there. It's beneficial for folks who are bringing the case forward. But if I'm thinking of the average consumer, if I'm thinking of someone like my mom or even myself, and I find out that a platform has used has violated the promise it made in terms of how my data can be used, am I really empowered as an individual at that point to bring a case forward? And I think what's more concerning to me is the fact that in this privacy debate, this has been sort of the poison pill, right? And that the conversation sort of hinges around these, private right of action is one, preemption is one. Glad we're hitting the controversial topics first. But those are the two issues that have sort of stopped the, from moving the federal legislation forward. I mean, the House bill leaves it out completely, right? The discussion, the bipartisan draft. And so that to me is, I think it's important to have these discussions, but I also wonder at some point when we talk about the political concessions we have to make, where's the give, right? And that's the sort of question I would pose, to the folks here and to the panel and the moderators as well.
But I think the example you brought up is interesting because it's different from the other example of the data breach, where there actually are, there are demonstrable damages. Okay, they may not be large, but at least there are damages. You're basically talking about a situation where somebody violated a rule and nobody knows if there's any harm. And so a private right of action there, I think, is, particularly, ripe for abuse.
Well, to bring this from the federal down to, the state and local level, since, Next Century Cities was so nice as to host this event, as we look at the issues you're raising about how do people know, how will these impact, how will we use this data in the future, how do you all see those issues playing out at the municipality level? And how will that impact smart cities and how some of our largest cities are trying to roll out services that are very data reliant?
At the local level, you're seeing not only a lot of regulations, proposals, and ordinances. You're seeing some advisory groups. For example, New York City is staffing up to work on their automated technology task force to look at issues such as algorithmic bias. You're also seeing a lot of cities like Seattle releasing proactive privacy principles, their sort of version of their fair information processing principles. So you're seeing all of this different action at the state level. And I think something that's really interesting and a question that a lot of folks are looking to in this area, especially in smart cities, you have cities working with often private companies to implement these technologies in these communities. And there are a lot of questions about who should be responsible here. And really, you have to look at these local governments and cities. If these technologies are going to be implemented, they're going to be responsible for regulating it. But there's definitely a lot of action at the city level, and I think folks at the state level and the federal level should really, pay attention to what's happening and these discussions.
Sorry, let me, if I can, I'll put a finer point on it. Jeremy, you raised New York, great example. I grew up in the Hudson Valley, just outside of New York City, and anyone that grew up in New York State, not in New York City, sorry if there's anybody here from New York City, will tell you everyone else that carries a New York driver's license has a chip on their shoulder about every law in New York saying, except in the 5 boroughs of New York City, these laws apply. As we look at the issues you're raising, how does that play out when you are a visitor to a city and you didn't have any input and you have no ability to be a part of the discussion in a municipality about how data about you is collected when you come in?
Yeah, that's certainly top of mind. You often hear the expression in this context, your data or your life. And this applies to folks living in the city, and it applies to folks moving throughout a city or working in a city. You might not live in a particular municipality, but you work in that municipality. And you really have no choice. Either you're going to live in this area or come through this area, and you're going to have your data collected, used, or shared in a particular way, in a particular context. And there's really, folks are not presented with a choice in this area. So that's definitely something to think about.
We've mentioned earlier that a lot of this conversation revolves around consumer privacy, the interactions between consumers and different companies, and the potential for regulation or the lack of regulation thereof, but that there's also a conversation about government access to data that is going on, somewhat related to smart cities, but also related to what the requirements for warrants or other access to different electronic information. And so, for example, Utah actually was a leader on this front. Last year, they passed as far as I'm aware of, is kind of the first of its kind legislation on a state level to establish warrant requirements for electronic information, basically doing away with the third-party doctrine on a state level.
And I just want to say quickly that that there, John, you mentioned just a moment ago some of the ordinances that are being passed in the cities around face recognition. A lot of those are community control over police surveillance ordinances, right? These ordinances that are designed to create a process hook for folks in their communities to learn that that the government, or specifically law enforcement agencies, are adopting a technology that could be classified as a surveillance technology, and then to learn more about it. And and that process has actually been pretty fruitful in revealing information that some citizens of cities were previously unaware of regarding collection of information as they were going about their business in their cities. And I know that for example, folks in Seattle have learned more about how devices at intersections and designed to monitor traffic collect information about MAC addresses of passing devices passively. That could be detailed location information. People just weren't really aware of that, and that as we think about legislation, as we think about what cities can do, these types of process-oriented solutions can be really helpful in delivering more information to people so that they can then respond and opine on what they think the rules should be.
So I'd like to turn just briefly to civil rights. What do you think about that? I'm just kidding. Many of the harms that manifest themselves in privacy, in artificial intelligence, in disinformation campaigns, seem to impact historically marginalized communities more than others. At least this is how I interpret it. Is the way that legislators in Congress and state legislatures and at the local level, is the way that they're going about privacy legislation, privacy regulation, adequately incorporating civil rights concerns? And are they looking to the right sources when they do look at that? We have plenty of civil rights laws around things like fair credit reporting and housing laws, and are those the right places for legislators who care about these issues to be looking, or are there other sources that they should be looking to when they're thinking about the intersection of civil rights and privacy?
I mean, so I'll start. I do think that in terms of, I'll speak to the draft legislation that we've seen, right? And the sort of consulting process behind the scenes with a number of civil rights and digital rights organizations. I do think that in terms of bringing the expertise and the folks who represent communities of color in the conversation, I do not think that they're necessarily adequately protected. I do think that the drafts we've seen do try to at least attack the idea of making sure that data that is collected cannot be used to discriminate against individuals. I think there's a start there. I do think, though, it's not enough necessarily just to have a provision that just says, you can't violate any civil rights. It's also about having algorithmic accountability. It's also about ensuring that you can have third parties test algorithms to ensure that there is no bias being tested there. So I do think that it's a start from my perspective. I do think that more folks should be at the table in terms of bringing the communities that they represent to the conversation. But yeah, I would say it's a start, but has not gone far enough.
Obviously this is all very new, and I think it's important for regulators or potential regulators to understand the context in any particular situation, of what's going on. And there's an interesting study by that people here may have read, by Catherine Tucker, an economist at MIT, where this is a lot of data and covered a lot of countries, and the results were all pretty much the same. So there's an advertisement for STEM workers, which it turned out was being shown to, I guess, significantly fewer women than men. So the question was why? Why? And it turned out, it was a very simple explanation, that there was nothing built in that was discriminatory in the algorithm. It just turns out that advertisers are willing to pay more, just advertisers in general, other advertisers, are willing to pay more for female eyes than for male eyes. So it's more expensive to serve that ad to a woman. So an algorithm like that basically was just trying to show the ad to the most people at minimum cost would end up showing it to more men than women. Now, so and it's not obvious. I mean, it's not obvious. You have to do a lot of work to figure out that that's what's going on, and then you have to figure out what you want to do about it. So.
Yeah, I'm glad that you brought that one up because that research is really interesting, and it's one example of multiple studies that have shown that discriminatory distribution of ads can take place even when the advertisers have not selected a demographic group to target, or when the engine is not distributing based on demographics whatsoever. Right. So the recent research that came out from a team at Upturn and Northeastern showed that when ads were placed on a different advertising platform, and that the advertisers did not specify an audience, that advertisements for different types of jobs were distributed in a way that was grossly disparate. Right, that was I think like 81% women in one case. Right, for I think an ad for a job for a grocery store cashier. Right, and in another case for an ad for a different type of job, maybe for drivers or something, it was shown disproportionately to black men. Right, the ads were distributed in a way that was grossly disparate, and it's just because of the way that the hypothesis is that it's because of the way that the engine was optimizing for engagement and choosing lookalike audiences to distribute the ad to. But all of this is to say that it's not enough for us just to have legislation that places particular restrictions on use of sensitive information, including demographic information. We really have to think of creative solutions to ensure that parties that are responsible for distributing information about opportunities like this are taking proactive steps to determine how disparate impact might be occurring and to take steps to try to prevent it.
Yeah, I would just second that. I think what we're all saying here, and I think KJ's absolutely right, that there needs to be more conversation about this area. But what we're seeing is that things happen unintentionally, and I think depending on how we have legislation, there can be some unintentional consequences to legislation too, because we're dealing with algorithms, which by nature, and I'm reluctant to say this because it might be taken out of context, you want them to discriminate in the sense of, I want them to separate classes of things and do the thing I want it to do, right? But you don't want it to discriminate in a harmful manner. So I think when we talk about this, what's the harm? If someone's seeing an ad for soap that they may not want to see, that's not that harmful, but if they're not getting a job opportunity or they're only being filtered to certain housing, that's extremely concerning. So I think when we think about what we're doing as far as legislation, we need to have kind of broad principles of transparency and explainability to be able to say, this is why it's making this decision. It's not discriminating based on these, protected characteristics or these ways that we would find concerning. So I think it's a little more complicated than just having a law that says this is how we do it. I think NIST is doing the right thing by coming up with standards for federal agencies, but I think we need to go further in the conversations that we're having to making sure that we're protecting vulnerable communities.
Based on I won't put words in either of your mouths, Sean or Laura, but it sounds like you both believe that if we tackle federal privacy legislation in the Congress, that this should be a portion of that bill. Am I hearing you correctly? The reason I ask, as you all know, tough bills have a hard path through Congress. Tougher bills have a harder path through Congress. Should these be issues that are all attacked in one bill, or are they separate issues that Congress should look at separately?
I absolutely think that we need to address discriminatory uses of data in privacy legislation. I think that it would be insufficient at this point in time. We are in a period of renewed broad societal interest in racial equity issues, and I would hope that we are with the broader recognition as well that there are uses of data that result in these terrible types of discrimination. I would hope that privacy legislation will incorporate some ways to attempt to address that.
Yeah, and most of the legislation I've seen has had some sort of civil rights section that does address this. I don't think that in and of itself is necessarily problematic. I just think that we need to be careful how we do it to make sure we're actually addressing the problem.
So much of the privacy debate up to now, at least as I've seen it, it sort of goes in ebbs and flows, right? There's sort of a general rising tide over the years to do something about privacy. But when I really see sort of the engine get moving, it's after you have motivating events. Snowden and the NSA, Facebook and Cambridge Analytica. I think a lot of folks are looking to the upcoming census and the upcoming election as events where we may see the impact of disinformation campaigns and a lack of regulation of how the platforms handle advertising, for example, or who has access to their data as motivating events. So I'm going to ask you in the little bit of time we have remaining to imagine that it's January 2021. Regardless of who you hope is getting inaugurated in January 2021, we will have passed the census and we will have passed an election. What do you think we're going to be talking about when it comes to dealing with these issues in January 2021 that have been informed by those two motivating events?
Don't all jump at once.
Regardless of who gets elected.
This is probably the least glamorous answer possible. But when we talk about the census, there's a lot of talk about de-identification standards and anonymization of data and the ability to maintain the utility of data, but at the same time protect privacy. Experts say that if this data has any sort of utility, then there's always a risk of privacy breach. So I think there's going to be a lot of talk about different de-identification standards and what that's going to look like. And I think in the privacy community, there's going to be an increased discussion of privacy-enhancing technology around this issue. And I do think in many of the federal proposals we've seen different definitions of de-identification, and I think we're still going to talk about those issues in a year. So that's like the least glamorous answer possible, but I think DID is going to be something we're talking about when it comes to the census.
Well, I assume that whoever loses will say that there was something nefarious going on from the other side. That's a given. But I think in terms of government action, if we're talking about content and information and essentially speech on all these platforms, this does seem to me to be a good area for the government to stay out of. But I do think that the platforms themselves have every right to try to and responsibility to try to police what's on their platforms, if only just to protect their brands. I think in the long run, if you have bad stuff on your platform, your brand is going to suffer.
So we have started to work with a few digital platforms on disinformation and misinformation as it relates to census and voting this year. And I do think, a lot of the conversation today has been focused on government and, at different levels. I do think that this year will prove to be a sort of an interesting test for those platforms in terms of how they deal with their rapid response in dealing with that, misinformation and disinformation, and also in terms of how they engage with civil society, right? I think a lot of platforms will initially start with the conversation by saying, look, you're a trusted flagger, tell us what you're seeing, and the idea that, again, like if we're curating our own feed to have an individualized process, we're not going to see the disinformation, misinformation, right? And so the idea that it's all on the user is sort of frustrating. So I do think that the test will be on corporations and platforms to see how they sort of engage on this issue and sort of the mechanisms that they create in terms of engaging with civil society to report out like what they're seeing and how that can be stopped.
Great. Well, we still have a few more minutes. We're good? We gotta wrap it up.
We're getting. We'll do one rapid fire if that works for you. I think to bring it home for Next Century Cities. Real quickly, Laura, we'll start with you. We'll go down if you can briefly to sort of sum up on what John raised. what is the dark horse issue that, as we've all talked about federal legislation, what's the issue that you think municipalities should be paying closest attention to as Congress considers federal privacy law? Laura?
Well, I've already mentioned discrimination. I really think that everybody should be thinking very hard, not just about how to ensure that users have control over their information, which is sort of a classic way that we've thought about privacy, but I think they should be thinking about use restrictions that prohibit harmful uses such as discriminatory uses.
I would say a dark horse issue is we're seeing a lot of states with public records laws that are quite out of date, that when written did not conceive of concepts such as privacy and transparency. And we have a situation where folks can essentially ask for any information they want in some of these states. So I think that that's going to be an issue that localities and municipalities are going to have to tackle in the future.
Yeah, I think for me, again, representing a diverse community in this privacy debate, the idea of transparency and how do we create sort of a gold standard of transparency to ensure that folks of varying backgrounds can understand the terms of service or the sort of the rights they have on a platform.
Yeah, for municipalities, I would say equity in the use of technology to ensure that we are using technology to serve all the people in our community and not just giving the benefits to one portion of it.
For municipalities and states, I'm going to in some ways echo Jeremy. I think government access to data and what data the government is collecting and what, if any, protections there are on that.
Yeah, I don't think I have much to add, just that municipalities should, I mean, they have their own brands and it's serving their constituents, so they should be responsible stewards and do what they think their constituents want.
Great. Well, thank you, everybody, and please join me in thanking our esteemed panelists.